Okay, so welcome back. We have two more topics for the morning. One is the very exciting topic of application forms. I know that everybody finds that the most exciting part of the whole process. Certainly the ones that have already worked with me through these forms. So we won't spend too much time on it just because there is way too much to know about these forms than we can cram into one morning, but I wanted to point out some of the most important issues. So first and foremost, I know this is hard to read, but don't worry about it, you'll get the slides. So first and foremost, there is a difference here between those PSR cases, so the private sponsor referred cases that a large number of you are sponsoring, and these so-called BVOR blended cases. So with the BVOR blended cases, we are only doing one set of documents, whereas with the others, we are doing two sets of documents. So do not jump to conclusions and say, well, if you haven't decided yet, that means you want to sponsor a BVOR case because it's easier. Because it's going to hit you after the fact with the BVOR cases. So the application process is simpler for the BVOR cases, but then after people have arrived, there's a whole slew of forms that have to be done to access the government support that is available for those cases. The so-called RAP support, Resettlement Assistance Program support. Those of you that have taken on these cases know that the government makes a half year's worth of support available at the local, the provincial income assistance level. But to access this money, as you can imagine, we're dealing with the federal government, you have to fill many forms. Okay? So a bit easier at the start, but then you have forms to deal with after the fact. So the two sets of forms are, first of all, the refugee application forms. They are called the IMM 6000 package of forms. These forms for the BVOR cases have been done overseas. You have nothing to do with them, okay? In the case of BVOR. If you are sponsoring somebody who is referred by somebody here in Victoria, we will have to do these forms together. And that can take a long time, as some of you know. Just because, generally speaking, when we ask family members to work with us to help fill these forms through contacting their families abroad, not everybody is overly forms literate, and these forms are not for the faint of heart. So it is not always entirely clear, in spite of there being an instruction guide, which is only available in English and French. And maybe at some point we'll find somebody who will translate that thing into other languages, but it is a very long guide, so it's not that easy. So we'll work on that. So we often work for a long time on these forms. They also necessitate so-called supplementary documents. Supplementary documents are copies of passports, of national identification cards that people have from their home countries, family books, marriage certificates, so all kinds of civil documents, birth certificates for children, educational documentation, so diplomas, graduation certificates, driver's licenses, military records, very important. If a male member of the family, an adult member, has served in the military, be it for compulsory service or otherwise, they definitely want to see these military books to see what kind of a rank that person was at, and that obviously has something to do with security screens later on. So there's a lot of stuff to collect. The good news is that as a sponsorship agreement holder, we are able to send into the immigration office scanned versions of documents. We don't require original signatures. We can have the applicants overseas sign these documents and then just take basically a picture with a cell phone, which most people have access to, and scan them back to us. And that's been a way that we've been dealing with these issues. So those take a long time. The other set of documents are sponsorship undertaking documents, and that's basically the set of documents that you and us, so the constituent group and ICA, do together, that basically says we are taking this on jointly as a responsibility to bring in these refugees. Again, there's a number of forms that need to be filled. I typically pre-fill parts of those forms and then send them to whoever the lucky person in the group is who has the task to work on forms. And then we basically get these 2 sets ready. It can take up to 2 months. We have this experience, and unfortunately it delays the process because the clock starts ticking when we put applications through to the centralized processing office. But my philosophy is, and it has worked so far, we try to send in documents that are as flawless as they can be. We haven't had any rejection so far. Sometimes we have heard that groups of 5, that were in a rush and sent in these documents, they had them rejected several times. So there's no value in doing that. So there are families, members and family members. So often, people have difficulty understanding this concept, and why would they not have these difficulties? Family members, according to the Canadian government, are certain people that make up a core family. And as per the definition, that's a father and a mother and underage children, so children under the age of 19. The minute a child is 19, they are no longer considered a dependent child for the purposes of the immigration minister, which doesn't mean that we'll leave these people behind, obviously, but they kind of become their own applicant, okay? So we are talking here about principal applicants, and this is a very important concept to understand. The principal applicant on a refugee application is the person with the strongest refugee claim. It is typically the father or the mother in the family. For some people, it doesn't really matter who becomes the principal applicant. Let's say if it is a Syrian family, and basically they're fleeing generalized violence in Syria. Maybe their house was bombed, they had to flee from that place. They were, in different places hiding out, and then finally left and fled to Lebanon or Turkey. Nobody was particularly targeted by anybody. It's just that they're fleeing the generalized violence. In those cases, it doesn't matter so much, and typically the father becomes the principal applicant. If, however, one of these 2 was actually targeted by either the government of the country they are fleeing, or by paramilitary forces, or anybody else, and the government turned a blind eye to it and was unable to protect that person, then they have an additional claim, okay? And then that person should become the principal applicant. So if that happens to be the mother, if something happened to the mother and she was actually, in addition to being a victim of generalized violence, also personally targeted, then she should definitely become the principal applicant, okay? The reason why this is important is that only the principal applicant on any application has to meet the eligibility requirements to be considered a refugee. The other family members are only assessed for their admissibility to Canada, and that involves those medical checks we talked about earlier and the security checks. They don't actually have to meet the criterion of being a refugee. So for example, just give you an example, let's assume the father fled to Lebanon and the mother and the 2 children are still in Syria. Yeah, just an example. Obviously the mother doesn't meet the criteria for being a refugee, as we've said earlier. She's not outside of her country of origin. However, if the father becomes the principal applicant, he's a refugee, he's in Lebanon, the rest of the family become the dependents on that application, and then basically they can come with the father. They're not assessed on whether or not they're a refugee. Problem is if they have a 20-year-old son or daughter who is still in Syria, because that person is her own principal applicant and does not meet the criteria of being a refugee, and then it becomes a problem, okay? Because then technically that person would be left behind, and that's obviously not something that we want to see happening. So those are some of these issues we're dealing with. Basically, Alexandra and I have more often than not cases that are less than clear. So the idea that, people come in sort of clean families of father, mother, and 2 children, and they're all in the same spot, that is not happening with refugees, because that's the reality of refugeedom. People are being torn apart by war and unrest. People lose sight of one another. Sometimes people actually don't know where 1 or 2 of their family members are, and that's the realities we're dealing with. So basically, there's a number of forms that all principal applicants have to fill. It's not really rocket science. It's actually really 3 forms. There is a generic application form, which is called the IMM008 form, and that has to be filled by the principal applicant, and they put on that form all of their dependents. So if the father is the principal applicant, the mother goes on that form, and the underage children that are dependent also go on that form. Just 1 form. If there is a 21-year-old daughter in that family, we fill another form, or she has to fill her own principal applicant form, because she becomes her own principal applicant, and that application gets linked to the core family, because she's not considered a family member by the Canadian government. And then there is these 2 wonderful forms called Schedule A and Schedule 2. Don't ask me why they're not called A and B or 1 and 2. They're called Schedule A and Schedule 2. So these forms are sort of, the way I see that, historical, dinosauristic, leftover from various governments that have made different changes to these forms over time. And they don't make an awful lot of sense, but they are what they are. And so that's probably how the naming of these forms came about, right? So, but they are what they are, and there might be changes, obviously, now coming with a different government. So we have the main form, the generic application form, we have a Schedule A and a Schedule 2. And that's essentially what it is, for the applicants, the refugee applicants. The Schedule A deals more with family relationships and where people have lived and their addresses and their educational attainments and all of that. Schedule 2 deals more with the person's flight story. So the narrative of how they became a refugee. This is a really important form. So right now, there's quite a bit of leniency in the system with Syrians, because the government has put special exemptions into place with Syrians. So they don't actually pay too much attention to what's in Schedule 2, as long as it makes any kind of sense, because you might remember that the previous government declared in September of last year that all Syrian refugees are so-called prima facie refugees. So it reverses the burden of proof. Normally a refugee who goes before a visa officer has to make the case that they are a refugee and why they are a refugee, right? So burden of proof is on the applicant. With Syrians right now, burden of proof is essentially on the visa officer. So if a Syrian appears before a visa officer, the visa officer would have to prove why they're not a refugee, right? So, but that's only in place right now for Syrians, nobody else. So any other person from any other nationality needs to pay really good attention to what they put into Schedule 2. We generally say that there should be a longer document attached that outlines in as much detail as possible how it came about that they became a refugee, and that includes dates, as much as the person can remember, and real details of the story. It can be very difficult for people to write that down because it re-traumatizes them, it makes them think about these events. Those are very painful events very often. They often involve the loss of family members. So this is a very, very delicate process. And typically, the family member here will get that story, maybe write it down in the original language of the person, and then we can get it translated into English for the application. Okay? So this is just to reiterate again about the principal applicant. So really, only the principal applicant has to meet the definition of being a refugee, not the dependents that count as dependents as per the Canadian government's rules and regulations. It's really important to keep in mind. So what do we do? Yes, yeah.
I just noted that thing about 19 and not married. So if they are married, does that wipe them out as being a...
Yes, that's usually problematic. So if they are 19 and over and are not married, we typically have no problem linking them to the original application. So, and this is via this mechanism. So there is something on one of the forms where it says multiple undertakings. You probably can't read this. So it says multiple undertakings there. So if we've submitted, for example, one case where there's a core family, father, mother, and 5 children, and one of the children is 19 years old. So what we have to submit is a full application package for father, mother, and the 2 children, and then a separate full application package for that 19-year-old person. And then we link these files together here. We say these people need to be resettled together. However, if that 19-year-old is married, then it's usually problematic and the Canadian government might not accept that 19-year-old because then they are seen as not, the idea is that you can link them and bring them in if they are, for all intents and purposes, still a member of that core family, even though under the law they're not, with the age limitations. However, if they are married, they are considered to have their own family unit. So one can try it, one can certainly try to bring them in, and one can always sponsor that other part of the family as well. If the sponsoring group is willing to do that, that can also be done. But they wouldn't be considered then to be part of the, of the family unit in any way, shape, or form. Okay. There's also exemptions in place if there's children that are over 19 and have, for example, a disability that makes them dependent on their parents beyond reaching that age limit, then they can be put through as if they were a younger child. So there's also a mechanism to do that. Okay. So the other really important piece is that can't be said often enough that all family members need to be included in the application documents, regardless of where they are or whether we know where they are or whether they might even be presumed dead, okay? Reason being, anybody who is not on that original form will have a really, really, really difficult time later on getting into Canada and might not ever get into Canada. And you might have heard news about such cases, certainly with under the previous government that happened every so often, that these stories hit the news, where somebody had been here and they had, 2 children, and maybe there was a child that they had never, maybe that child was born while they were in the process of getting their own permanent residence here, and they could have simply forgotten, to write to the department and say, well, there's another child now, right? If people don't do that in these original forms, they will have a really difficult time ever bringing these dependents. So it's important, even if they don't know where they are, to put down their name and say there is another person, that we have lost track of. So another thing that's important, not so much for Syria right now, because obviously you don't have to put any country information into your application. If you're sponsoring a Syrian, that would be just a waste of time. However, for other populations that are being sponsored, it is very useful to put country information in. And it can become vitally important. So for example, I'm going to use Cyprus again as an example because it is such a tricky situation. So we have one group sponsoring out of Cyprus, and we have a number of family members that have come to us that have relatives in Cyprus. The reason why many people are trying to go to Cyprus is because the conditions are somewhat better than in Turkey. And even though they generally can't find work there, unemployment is sky high, they generally feel safer there and they're not treated as bad as they are in Turkey. Cyprus, I'm not an expert in Cyprus for all intents and purposes, but you might know that it's divided into sort of a southern part that is its own, country and has EU member status, so it is a European Union member state, and a northern part which is occupied by Turkey and is basically not recognized by any country in the world other than Turkey as being Turkish. There's sort of a green border between these two parts that people can allegedly fairly easily cross. In the northern part, there is no asylum procedures, so people don't have any access to making a refugee claim and being recognized as a refugee. In the southern part, being an EU member state, they have to abide by European Union rules, so people can make an asylum claim there, and people get temporary protection status. It's very temporary. It's only one, excuse me? Oh, sorry. It's only 1 year protection that they typically get. which is of course not great. And as I said, the unemployment rate is sky high, but they do have the right to work. So it's stated right in their protection document. So many people are making the claim that they do not have a so-called durable solution or a third country, safe country solution in Cyprus. And we will need to see, we have to put this application through now, and we'll need to see whether the Canadian government buys that or not. So I have communicated with the visa officer in Rome that is in charge of Cyprus to ask her about how they see these claims, and of course you get a sort of non-committal answer, which was something along the lines of, you know, if we get an application and the person is making a valid claim that they do not have a durable solution, we will process this application based on rules of fairness and whatever. So that's basically the answer I got, which I think is positive in the sense that they didn't outright say we are not processing applications out of Cyprus. We certainly know that some people have been rejected their asylum claims in Cyprus. We're not entirely sure. This is just coming from some listservs that we are part of, why that was the case, because we don't usually ask details of cases. But I know that in those cases, certainly the refugee applications for Canada were successful. So if Cyprus had actually rejected and we were able to show that they had been rejected. Northern Cyprus, as I said, an altogether different story. We don't know what the Canadian government would say, you know, whether they would say, well, the person can just cross the green border and go to southern Cyprus and make a claim there. It's very difficult. So in those cases, it becomes vitally important that we research and find background information. And this is something that sponsoring groups can certainly help with, you know, because as we've said, we are very, very busy in our offices, and that often takes some time and effort. And while we can point you, you know, to the places where you can find these country conditions, it would be very helpful if in those cases you would do that background research so that we can submit the documents with the application. So something else, two pieces that are very important here are the 1-year window of opportunity and the add dependent form. So 1-year window of opportunity has to do with family members that are part of the application, but that for whatever reason are unable to come on the original application. So if we think about the case that I mentioned earlier, let's say there is a father in Beirut, in Lebanon, and the mother and the children are still in Syria, or they might be in Turkey, you know, they might have gotten separated. So what happens is that on the original form, there's the principal applicant, let's assume it's the father. The other family members will be put on there as non-accompanying family members. Typically, the Canadian government doesn't want to deal with accompanying, because then they would have to get that principal applicant to the rest of the family, or the rest of the family to the principal applicant first, and try to process them together, which is often logistically not possible because different countries have different processing mechanisms. In different countries, the Canadian government works in different ways. So in Jordan and in Lebanon, the Canadian government works a lot with the United Nations. In Turkey, they don't. They have to work with the Turkish government. If people are still in Syria, it's an altogether different story, and they would have to somehow try to get people out with the help of the United Nations. That is basically why the Canadian government wants these people put through as non-accompanying. So if they are accepted as non-accompanying core family members, then the 1-year window of opportunity applies. And that essentially means that they have a legal right to follow and join the principal applicant within the first year of the principal applicant's landing in Canada, which is important for sponsoring groups because it extends your responsibility, right? So let's assume that father arrived, on the 1st of January, and now you're putting through a 1-year window of opportunity application in June, of that year. And now this other person maybe comes at the end of the year when technically your, year for the father is over, but now you have another year, right? Because then your sponsorship is extended for the people that came later on under the 1 year. So that's just important to keep in mind. So you definitely want to know upfront who else might be there, who has the right to come. It only applies to people that have been put on the application. I should say that very clearly. If a family arrives and they all of a sudden say to you, well, we also have a 17-year-old daughter and she actually went with her aunt to Lebanon and can we bring her now? If that daughter was never mentioned on the original application, it's going to be very difficult. And of course, there's a lot of moral pressure on you to somehow make that happen. And I'm not to say that it can't happen, but it's pretty messy, and the government may or may not look favorably upon that. Hopefully, with this government, they will. I mean, family reunification is one item that in the sponsorship community, in the settlement community, we always push for, that families shouldn't be separated. But we don't know. Technically, legally, they don't have to do it if they don't want to do it. So. The ad-dependent issue is basically where during the process, somewhere in the course of the process of sponsorship, a new dependent is showing up, okay? So you can still then put that person on the application without there being any kind of punishment or the government saying, well, no, now you can't, right? It's not the same as when the people have already landed in Canada. So let's say what happens very often is a child is born, in the somewhat lengthy sponsorship period process. And so now this child, because they're not on the application, obviously, in order to get them on the application, we have to fill an ad-dependent form and put that through to the government. It's just, it's not a complicated form, but it's something that can get forgotten, and then it becomes an issue later on.